Now turn to the sixth case on this morning's docket, case number 117167, in the matter of the petition for a writ of habeas corpus by Clay Snyder.
May it please the court, Petitioner Clay Snyder appears by Mark Dinkle, Salina Public Defender Office, would request 3 minutes for rebuttal.
3 minutes is granted.
Mr. Snyder was born with microcephaly, which I had not heard of when I got this case, but since then we've been through the Zika virus, and I think familiarity with it has been gained generally. Literally in Latin, it means small micro head cephaly. And it results in intellectual disability, compromised intellectual functioning. In the course of the habeas proceeding here, we filed a motion, this is original action, we filed a motion to take judicial notice of information we presented to the trial court from the Centers for Disease Control website on the condition of microcephaly and attendant intellectual limitations potentially. Mr. Snyder's journey down this path to where we get to here today, in the 5th grade, a school psychologist in Salina evaluated him, evaluated his intelligence, described it as crystallized, which I interpret to mean that that's something that's not going to change. D. Oelian opined that his intelligence falls in the 1st percentile or below, as far as that goes, and that in the course of these proceedings, that really hasn't changed. Dr. Trevor Patton examined him, found his intellectual functioning in many aspects was below the 1st percentile. 11 of 14 competency examinations in this case found Mr. Snyder incompetent to stand trial. I think forever raising a cloud as to whether he could be validly convicted of the crimes with which he's charged.
Well, counsel, given all that, what do you want us to do? I mean, a lot has happened since you filed your habeas action, and trying to figure out how that all plays together has been challenging for us.
I understand.
And so let's start.
It's challenging for me as well.
Well, but let's start with what do you want us to do?
The request that we would make is for this court to order the criminal charges to be dismissed with prejudice due to due process and speedy trial, constitutional speedy trial violations. There's a kind of a secondary concern of equal protection of how intellectually disabled, how their speedy trial rights may be somehow lessened in comparison with those who do not suffer that disability, who may be mentally ill. Part of that is the nature of the beast of intellectual disability. I've cited scholarly articles that indicate that in cases of people with intellectual disability to attain competency, and that's, I think, what we're talking about in Mr. Snyder's case, not restoration, but attainment.
If dismissal of the criminal charges does not result in Mr. Snyder being released from custody, is that a remedy that's available to us in a habeas action?
Well, it releases him from custody on criminal charges, which he's on. Even being on bond on criminal charges, being in custody for purpose of habeas, which he's not. He's never made bond. But it would release him from that hold.
But he'd still be confined by the state of Kansas.
Potentially on the care and treatment.
Well, he's forever dangerous because of the nature of the charges, isn't he?
By statute.
By statute, right.
Well, That's a matter maybe for a habeas in a care and treatment case.
So what you're seeking is release from confinement on your case, and whatever happens, happens.
And
But
Jackson
Mr.
versus-
Snyder's still going to be confined.
Yes.
His liberty is going to be deprived.
The tail end of Jackson versus Indiana, the last page of that decision right before the ruling, they talk about that remedy in that opinion, that when people are not restorable, that what traditionally has been done is the charges are dismissed with prejudice if there's not going to be any progress made. And that's the situation we have here. We have somebody where progress almost by definition cannot be made.
So all you're seeking is a remedy on your criminal case.
That's all I'm seeking.
And so
Yeah, I just represent him on the criminal charges. And we're talking about somebody who's been confined for 5 years and 1 month.
Can I ask you about a particular period of time within
Yes.
that I'm confused about? And it's from roughly the end of September 2014 to November of 2016.
Yes.
And it looks like the district court in September of 2014 entered an order to the state to commence involuntary commitment proceedings. And then in the next thing I see is 2 years later, the state conceding Snyder's not competent. I don't know what happened between
Okay.
those two dates.
And I think that we initially opposed this in the district court, but the judge took a very enlightened approach to this case, ordering independent experts to evaluate him. Prosecution submitted 5 names, I submitted 5 names, and generally Judge Johnson took the top 1 or 2 from each list, and that's how we get all these 14 evaluations in addition to our expert. In September 2014, Larnard, I believe at that time, reported that he was incompetent to stand trial and unlikely.
Right. Unlikely to gain competence.
And they noted in that report that his detainment since 2012 had negative impact on that.
Right. So the district court follows the statute and says, well, state, you better start your involuntary commitment proceedings.
Well, as I read that statute, and I didn't raise this specifically in the habeas, but that statute 3303 has Jackson versus Indiana time limitations. Those were enacted following Jackson versus Indiana to ensure due process. And just reading it here just before court, if Larnard says that he is incompetent, unlikely to regain competency in the foreseeable future, then the judge shall order him back to Larnard for 6 months to attain competency, or for 6 months, whichever occurs first.
And that had actually already happened earlier, those procedures. Let me just cut to, do you know whether or not Snyder was involuntarily committed by a court?
He was in. We checked
In 2014.
In 2014, we checked that. I consulted.
And how long did that involuntary commitment last?
I don't know
Did
how
it
long.
go all
that
the way up till that November?
I would
date?
guess up until Larnard in 2016, July 2016, end of June 2016 said he's competent to stand
If we're
trial.
just trying to figure out the length of time your client's been held solely on the criminal charges, we would need to exclude those 2 years because he was being held in addition under an involuntary commitment.
Well,
That's what I couldn't tell from the record. That's why I'm asking.
yeah, Jackson versus Indiana uses that language solely on account of his incompetency. Is the language on?
I'm just trying to get the facts straight before I try to decide what that means.
This
Let
isn't
me ask
really
a different way. Was there ever any Chapter 59 involuntary commitment proceeding instituted before the current one?
Yes, there was. There was one in 2014, and I advised Ms. Curtis of that. And we were, and I put it, I think, in paragraph 32 or 33 of the habeas petition. But there was a Pawnee County involuntary commitment proceeding, not in Saline County, but in Pawnee County. And Mr. Smith, who's a practitioner in Larnard, it was one of his partners, I think, who defended it at that time. This is what he advised me. I didn't know the name. I think it was Leonard or something who represented Mr. Snyder at that time, but there was an involuntary commitment proceeding.
And what was the date of that proceeding again?
That
Pawnee
would have
County?
been in 2014 to 2015 sometime. There would have been a proceeding in Pawnee County, and this came up just in connection with filing all the supplemental briefs and everything, and Ms. Curtis and I were discussing argument strategies. And I had put in my petition that he was involuntarily committed. And I said, I hope I didn't drag that out of thin air and or something, and I didn't. I checked. I checked after putting that in there that there was a case number in Pawnee County, 14 CR 13 or CT 1358 or something like that. Whichever one. I had a case number that was associated with that. I obtained that from Pawnee County District Court. So there was a care and treatment proceeding instituted at that time. In the course of that proceeding, in the course of that commitment, the concern of Jackson versus Indiana is that if somebody suffers a massive curtailment of liberty that is an involuntary civil commitment, described by the United States Supreme Court as a massive curtailment of liberty, I think it was Humphrey versus Cady, maybe the decision there, and Jackson versus Indiana being issued in the same year, 1972, by the United States Supreme Court as Humphrey versus Cady. The concern with Jackson versus Indiana is that massive curtailment of liberty has to be marked by progress towards competency. And we didn't have that in 2014 to 2016. The reports that were filed by Larned, and they're not reporting to Saline County District Court. You've seen some of their reports from Pawnee County District Court. They're not submitting these to Saline County District Court, but they were at that time. And those reports started saying that Mr. Snyder was making slow progress, the first two reports, and the second two reports, and you've seen one of those in the supplemental briefing, then they downgrade that to minimal progress. And then suddenly in June 2016, he's whipsawed back into court, criminal prosecution, because now they say he is competent to stand trial. After they just 3 weeks after submitting a report saying he has made minimal progress. That's part of the prejudice that's adhered to him, is he's been returned multiple times from Larned State Hospital, declared to be competent to stand trial, and not competent to stand trial. And he ends up spending time in jail while we do all these independent evaluations. That takes a little bit of time to set up and schedule doctors. He spends that time in jail, and then he's eventually found incompetent. A week from today, a large marmot will arise out of a hole in Punxsutawney, Pennsylvania, and declare to us whether winter's at an end. Probably not. It's Groundhog Day, once again, for Mr. Snyder in the competency proceedings. Back and forth, back and forth. The only agency that declares Mr. Snyder competent to stand trial is Larned State Hospital. His speedy trial rights have been violated constitutionally. The length of the delay, 5 years and 1 month up to today. That's beyond a presumptive prejudice analysis. He suffered extended periods of confinement in the Saline County Jail. He suffered not a progress toward competency, but as Larned themselves admit in the September report, the detainment in the jail has moved him away from it, has decreased his already limited mental functioning. The reason cannot be ascribed to his intellectual disability. The state has the obligation to bring him to competency. That's their undertaking. And they're trying to treat something that you can't take a pill for. You can't take a pill for intellectual disability. The memory problems, you have the most recent report declaring him competent to stand trial. Even there, they said, you got to go slow with him because of his memory problems. The trial would have to be marked by frequent recesses where his attorney would explain to him slowly and clearly and to where he can comprehend what has just occurred. That is not a report of somebody who's competent and able to assist his attorney in defending a criminal case. He's certainly asserted the right through counsel. We've been asking, and that's what the 10th Circuit says is perhaps the most important factor in the speedy trial analysis, is assertion of the right. And we've been doing that now for nearly 3 years. In March, it'll be 3 years where we've been objecting to continuances and asserting the right to a speedy trial on his behalf. That's the most important factor. I would submit to this court that base has been covered.
I shall earlier ask you what you wanted us to do, and that was to have the criminal charges dismissed with prejudice?
Yes.
And that's still your position?
Yes.
Anything further?
No. Thank you very much.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Chris Elsliger appearing on behalf of the state. The majority of Mr. Snyder's habeas petition is grounded on his alleged claim his right to speedy trial has been violated, which makes this kind of an interesting case because we come to the tension between a couple of constitutional rights. I mean, because he's not competent to stand trial, he has a constitutional right, a due process right, not to be brought to trial until he's competent. So the state can't try him. And as some of the case law and even the district court judge recognized that the traditional Barker v. Wingo analysis kind of presumes that the state could have brought the defendant to trial, but in this case we can't. He's not competent to stand trial. And so it puts us in a quandary, is that we can't bring him to trial, but we also have to protect the public. He's dangerous, and so what do we do?
Well, is one of the things that you can do that you can ping pong him back and forth between competency and care and treatment indefinitely? Well,
that certainly is not the intent of the state, to ping pong him. The reason I think, in looking at the record, why it appears that he's gone back and forth, is both actions by the defendant, as is his right to challenge his competency, and then the determination by experts at Larned. At some point, some of them said, well, he's competent, but then when they brought him back, the defense says, no, they challenged it again. And that's their right, and
we have a court determination at least once, maybe more than once, that not only is he not competent, but there's no substantial probability that he will regain competency in the future.
That's true, and under the case law, the proper course of action, and the statute and the case law, is then to subject him to civil.
Right, and that's, I guess, the root of my question. The statutes at least appear on their surface to permit the state to do this, what I call ping-ponging, and maybe that's too pejorative, but to move an individual back and forth, and there's no end. And that's my question. Is that constitutionally permissible? It appears to be what the statutes say you can do.
It is constitutionally permissible.
So that could go on for 50 years.
Because there could be an end. I mean, he could gain competency, or he could cease to be a danger, and then he could be released. I mean,
right.
and
you're just to be clear, your argument is there's no constitutional impediment to what these statutes appear to do. Again, assuming my description of them is right.
No, absolutely. In fact, I mean, when it comes to speedy trial, there's a couple aspects. There's speedy trial and due process. When it comes to speedy trial, I mean, I've looked every single court that I could find that has addressed this has said, look, when a guy is incompetent to stand trial, it does not impact his constitutional right to speedy trial. If you were to decide otherwise, you would diverge from every other court in the country.
How does he cease to become dangerous?
Well, that, I think, is a determination for the psychiatrists, the psychologists, to take in their estimation.
It's going to be he was charged with an off-grid felony.
I think it's more than that. It's not just the charge. I mean, they have to. The experts conduct their interview of him. They do their clinical analysis of him. They treat him.
But they've done that.
And they've determined that he's still dangerous.
But I don't understand
Only based on
where
the charge.
dangerous comes into play when we're talking about competency to stand trial. I mean,
Well,
you
no.
can be very, very dangerous and be competent to stand trial. You could
Yeah.
be very docile and be incompetent, and it has nothing to do with that calculus.
Right, and that's where we're getting to kind of the two
Well, you're
cases are
mixing and
conflating.
matching.
Right.
He could, but that
The
wasn't
dangerous has
the
nothing to do with
question.
competency.
How you get out of the cycle of the competency, which we have here. It wasn't the dangerousness. I don't think that the question involved. It was the competency to stand trial cycle. How do you get out of that for someone who has a congenital brain problem that makes them intellectually disabled, and that isn't going to change?
Right. I think the way the statutes and the case law end the competency cycle is when you get to the point where the experts say he's never going to regain competency, both the statute and the case law say, okay, now you have to civilly commit
But
him.
didn't that
Why
happen
doesn't
here
the-
someplace, excuse me, but didn't that happen here someplace long before 2017?
Yes, and listening to the discussion with my opposing counselor, so it happened. I noted this in the brief.
It's happened twice at least.
2014, yeah. And then,
The potential problem is that at the end of that process, the care and treatment statute kicks you back over into competency. I mean, each process set out by these two different statutes ends. One of the possible end is to send the person to the other proceeding, and you just can go around.
but
and
there
around.
is an out. If I and I'm going to go from memory, but in this. If we send him to the care and treatment statute, and then the experts determine that he's not a danger to self or others, and that they don't want to commit him, then at that point,
He doesn't get released. What happens is that the state has to provide notice to the prosecuting attorney, and the prosecuting attorney gets to ask for a competency hearing. That's what the statute says, right?
you may be correct there. But I mean, at some point, I think that we would reach a practical end, though.
And that's the question. How do we know when we've
How,
reached the
how
end?
much longer?
And why isn't the time when he's under care and treatment order, apparently for at least 2 years, from 14 to 16, count against the state on speedy trial?
Well, as I said, I mean, every single court, the federal and state that I've found.
That's incompetence. At that point, he's not being held because of incompetence. He's being held under court order because of a care and treatment determination of dangerousness.
Well, he's not being held on he's not being held on the criminal charges anymore.
Yes, he is. Those are still pending.
I mean, I would say that the best case I could probably point to is the Greenwood v. United States case. That was the United States Supreme Court. In that case, he had criminal charges pending over him for, I think, a little over 4 years. Same kind of thing where you kind of ping-pong back and forth, although the issues in that case were not the same as what you have here.
I just think a distinction is that the state, the experts and the courts have basically given up on him in a competency proceeding at that point, and they've shifted him over to the civil commitment. And so that seems to distinguish it perhaps from all of these other cases that look merely at the cycle of incompetency within the criminal proceeding as not counting for speedy trial purposes.
But, I mean, certainly the reason he's committed, though, I mean, he's committed because he's not competent to stand trial.
No, he's committed because
I mean,
he's mentally ill and
he's mentally
dangerous.
right. I mean, but the practical fact is he's intellectually disabled. He can't stand trial, and he also can't be released to the public. I mean, that intellectual disability is fundamental to both.
It's your criminal charge that's providing the basis for his involuntary commitment. I mean, and so how does that work? You say he's not being solely held on the charge, but he is being so, because that's what's providing the reason for his deprivation of liberty.
Yeah, they're definitely linked, and you know,
More than linked, it's dependent on.
although it's not just the charges that provide the evidence of future dangerousness, but certainly, I mean, the intellectual disability is fundamental to both the competency and the commitment. I mean, they're not practically separated. It's the same objective fact. The future dangerousness is an assessment made by the clinicians that keeps him there. Now, you are correct that the criminal charge changes the category of what counts as mental illness, but the standards for commitment that the clinicians use are still the same. So I think that the requirements of due process are met. Ultimately, nobody's trying to railroad Mr. Snyder here. From I'm talking to with KDADS and the Saline County attorney in our office, we're just trying to figure out what's the right thing to do with this guy. I mean, we can't bring him to trial, but he's also, he's from the allegations, committed a very serious crime, and he's dangerous. The clinicians say he's dangerous. So what can we do with him? I mean, we can't bring him to trial.
If you can't bring him to trial, why are you fighting so hard to hold on to the criminal case?
Well, because this is a question I asked, actually. There's a little ambiguity in the statute as to whether, and I think this was brought up in the earlier argument, if the charges are dismissed, does the civil commitment standard stay?
I mean, you realize what that means.
Yes, we're in a big circle. I understand.
You mean you got to keep the criminal charges going so you can keep him confined?
I will tell you my opinion is I don't think that you need to keep the criminal charges pending, but the statute's not clear. It doesn't say one way or the other. So that is the fear. And I know the Saline County attorney's probably going to beat me up afterwards, but I don't read the statute that way. The statute says where someone's been charged with a serious crime and found incompetent, then they go to the civil commitment proceeding. And it doesn't say that the charges have to remain pending. Now there's another statute, I think it's 3305, which mentions in which the criminal proceedings are pending, but that you kind of have to read into that to read a requirement that the charges stay pending. And I think the court could easily, I mean, you could rule that the charges don't need to stay pending for the civil commitment, that the fact that he was charged and found incompetent is enough. And you wouldn't be a situation like you suggested where, well, he committed charges 20 years ago, and that wouldn't happen because we're talking about he's charged and found incompetent on those charges, which leads to the civil commitment.
Isn't that what opposing counsel was suggesting earlier when he said we're asking you to dismiss the criminal charges with prejudice? I thought he acknowledged that his client is still in custody on the civil care and treatment.
Yes, but I would dispute dismiss with prejudice. I don't think they need to be. You dismiss charges with prejudice if there's been some kind of constitutional violation. And what I was answering his question as to, well, why are you fighting so hard to keep the charge? And the reason is because on the state side, there's some disagreement on what if it's actually required or not, and also as it feeds into the SVP.
Because that one avenue I could have seen is you could have voluntarily dismissed this without prejudice and just pursued civil commitment.
And while I believe that is entirely possible under the statute, I think we would need the court to tell us that, because there are others on the state side that don't quite read it that way, or are afraid that it might be interpreted differently. And I was going to get back to your question, and I've lost my train of thought, Chief Justice.
Let me interrupt you.
While his train is still gathering steam, let me tell you, I think you've answered it.
It's with prejudice versus without
Right.
prejudice. I think you were going to explain that a little more, maybe, if you need to.
Well, yeah, I don't think there's been a speedy trial or due process violation here that would require dismissal with prejudice. I think you can dismiss without prejudice. The fear on the state side is that that you could construe that civil commitment statute in 3303 as requiring that those charges be pending. I don't read the statute that way. I think a reasonable person could read the statute and say that it's enough that he was charged and found incompetent to lead to the civil commitment. The other thing is the potential for commitment of a sexually violent predator. Again, it also contemplates charge and being found incompetent, and it just depends on how you read the statute. I think